why the government wants to control it. That's the only reason. Rajeshri, habitat. See, Supreme Court understood that inherently it is, but since it was not mentioned here very clearly, they went for the literal reference of it. Okay, Mayank Wadhwani. Anyway, so let me just recapitulate very quickly what we were discussing. So the story so far is that initially the rights were amendable, later on the rights are not amendable, which has placed a restriction on the government from doing what? From trying to sell the land, or rather take away the land of the rich and give to the poor. An obstacle, an impediment, an obstruction in the land reform provisions. Now, Indira Gandhi comes into picture. Indira Gandhi says that let's do one thing. This whole issue is all about Article 13. This clause, this Article 13 is a problem. This Article 13 is a problem. And what is a problem? The problem is that it is placing a limitation on everything, that we can't do certain things, we cannot take away fundamental rights. Yes or no? Okay. Abhishek, I can transfer the money on that behalf, right? That's what I can do. Rather than struggling for that, it would be more appropriate for me to transfer you the money if that is lost. But beyond that, it's beyond me. Who is this fellow? I don't even know that fellow. So I have no idea. Anyway, what did the parliament do? Very simple, very beautiful. Parliament made two modifications. Point number one, 24th Amendment Act was passed in 1971. And what was that? Article 368, Clause 3 was added. It said that Article 13 will not apply to amendments. Simple. What is Article 13? You can't make a law to take away rights. That is not applicable to amendments, meaning amendments can be made. The result of this was Parliament can amend fundamental rights. I hope this point is clear. One more change was made in Article 13, Clause 4. Nothing in this Article 13 will apply to amendments, meaning the restriction imposed by Article 13 that you cannot take away, make a law to take away rights, that is not applicable on the fundamental rights. Fundamental rights that is not applicable on amendments. Amendments can be made to take away your fundamental rights. I hope this point is clear for everybody. Is this point clear? Tell me. If these statements to you are not clear, just understand that these changes meant this. Simple. I will start from here again. 1951 to 1966, Supreme Court said rights are amendable. 1967, Supreme Court said rights are not amendable. In 1971, Parliament again modified the Constitution to say that rights are amendable. Are we clear? Rights amendable, not amendable. Because court has said it is not amendable, Parliament amended the Constitution and said no, rights are amendable. Are we clear now? Everybody? The chain of events? Okay. Now, a parallel story was running in the country. That story was of the chief pontiff, the chief priest of the Ednir Mutt in Kerala. And that was one Keswanand Bharti. Keswanand Bharti was a seer of the Ednir Mutt, the priest. In 1967, the Kerala government, under the First Amendment Act's provision, took away his temple property. He went to court that my fundamental right to property of my religious group is being taken away. This is wrong. But in the meantime, the parliament made this amendment that rights can be taken away. So now the problem is that Keswan Bharti was trying to rely on the Golaknath judgment. That in the Golaknath case, the Supreme Court has said that rights are not amendable. And he had filed a case in court in 1970. But in 1971, government said, sorry, we can amend everything. Now he's trapped. Now the matter changed in the court. The matter changed to this only. How can government make a change like this? That rights are amendable. The court has given a judgment. This is wrong. This matter was being asked in the court. And this is what was the Keshwanand Bharti case of 1973. This was a case which ran for 68 days. 68 days of discussions. Every day, the court is discussing this only. What is happening? Can rights be amended? Can rights not be amended? What to amend? What not to amend? What's the extent of parliament's power? How much can they amend? Can they change the entire constitution? All this is being discussed every day. This is the longest running case in the history of the Supreme Court post-independence. Second longest one is the Ayodhya case, of course, which ran for 42 days of discussion, and Aadhaar case, which ran for 38 days of discussion. Anyway, a 13-judge bench with a 7:6 majority, the closest majority possible, upheld that yes, Parliament, absolutely correct. Fundamental rights are amendable. Are we clear on this? Everybody. In the Keshwanand Bharti case, Supreme Court said fundamental rights are amendable. Parliament, you have made a change. Very good. We have no problem. So Supreme Court actually cancelled its own judgment in the Golaknath case and said rights are amendable. Go, enjoy. As the government people, the government's lawyer was leaving the court, the dancing and rejoicing, the judges said, wait, where are you going? Come here. See guys, dear advocates of the government, you are free to amend everything. Article 368 allows you, but not everything. You should not amend the essence of the Constitution. The value system, that should not be amended. The cornerstones, the crux, the underlying idea, the central idea, that can't be amended. The lawyer said, my lords, what is this cornerstone? What is this essence? So court said, see, you can amend everything, but not those basic features. The basic features of the Constitution can't be amended. That would be a reference to the basic structure of the constitution. If you amend the basic structure only, then the original constitution's essence or idea is lost. This is what we are giving to the people, this concept of basic structure doctrine. The lawyer said, my lords, what is this basic structure doctrine? How to define it? Court said, we don't know that. There is something called basic structure. There are some very important elements. As and when the time comes, we'll define it for you. But understand that we have to examine the boundaries of amending power, and amendment should not alter the identity of the constitution. Are we clear? So Supreme Court said that you are free to make amendments, but amendments must not alter the identity of the constitution. This is what is the basic structure doctrine. Simple. And the court also said that, for example, supremacy of constitution, the sovereign nature, the democratic nature, the republican nature can't be changed. The secular character can't be changed. Separation of power has to be there. The federal character can't be changed. All these are elements of basic structure. There is no definition. There is no definition. But there are some very basic things which cannot be changed. And the idea was very simple. Imagine in today's day and age, the world of, we are living in the world of plastic surgeries and photoshops. Imagine you get a heart transplant, a liver transplant, kidney transplant, face transplant, Botox injections, nose job, liposuction everywhere, hair transplant, everything is changed in your body except your right hand thumb. This remains original. Other parts, the skin grafting has been done, everything has been changed. But since the thumb remains the same, should we call you the same person? Tell me. Oh, so some of you are saying yes. Means the thumb, your entire identity is your thumb only. Is what you are saying. Your brain has been changed, your body has been changed. So for those who are saying yes, your identity is your thumb. Is that correct? Interesting. Right? So if you change everything, including your face, brain, everything, and not the thumb, then you are not the same person actually. Mayank Badwani, biometric scans will confirm that you are the same person. That's the whole point. The biometric scan says that, the thumb impression says that, not all the biometrics. Iris scan will not confirm. Then what to do? Right? Anyway. So the DNA is also changed. Everything is altered, but the thumb remains the same. Okay? So the point is that if you change everything, somebody is saying how to change the Ashay. Of course, who else would ask this question? Understand the inherent meaning, sir. How to explain giving examples? I did not create this example. In the court, lawyers gave this example, and the judges understood the underlying meaning of the example. But of course, why would you understand it? So somebody is saying, is it actually possible? Sir, we are not getting into whether it is possible or not. I am giving you an example to help you understand that if you change every provision of the constitution, then would you call it the same constitution? That's the question here. Right? So the idea is, if you change everything, then you are not the same person only. Right? So if the parliament gets the power to change everything, should we even call this constitution as the one which we gave to ourselves originally? Of course not. That's the real problem. And that is why this concept was brought by the court. Did we understand the basic structure doctrine? Now we have some idea on basic structure, yes or no? Okay. It seems that largely people have understood. That would be my assumption. So based on the assumption, I'll just give you some examples of how Supreme Court found examples of these things. The basic structure doctrine has not been defined, but the court has given examples of what you cannot take away, what you cannot change. Look at this judicial review. So tell me, we have seen so many articles now, we have seen the LEJ. Did you find the word judicial review mentioned anywhere explicitly? Tell me. We'll come to that. Dvaipayan, Krishika, I would love 21. There is no, it is not mentioned anywhere in the constitution, this word judicial review. Are we clear? Though you may say that, but judiciary has the power to review because they have given the power to themselves. That is why. Are we clear? So yes, we can derive its meaning from Article 142, Article 13. That's possible. But the word being mentioned explicitly, no, 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 no. This word is nowhere mentioned in the Constitution. But Supreme Court now says that not only is this word important, it is also the part of basic structure. So they have also made a part of basic structure those things that are not mentioned also in the Constitution. But anyway, in the Minerva Mills case, Supreme Court said that judicial review is a part of basic structure and it can never be taken away. That is why back in 1992, in the Kyoto Holohan case, when the Schedule 10 of the Indian Constitution said that the Speaker's decision cannot be challenged in any court, Supreme Court said, how dare you take away my power of review? It is a part of basic structure. I will look at it. So they use the same argument. Are we clear? So this is how the Supreme Court has widened its scope and ambit. Independence of judiciary. Look at this. This was used in which judgment? There was a judgment where this concept was used to cancel an amendment. The fourth judge's case. This was used to cancel the 99th Amendment Act 2014. Yes or no? That the independence of judiciary, which is a part of basic structure, is being compromised. Then various things. Now, are fundamental rights amendable? Tell me yes or no. Just say yes or no. Yes, of course they are. Fundamental rights are amendable. I have mentioned here. Please don't say no. Please pay attention. But Supreme Court says that, see, rights on their own are amendable. No problem. But you should not amend the essence of those rights. Essence is not amendable. The underlying logic is not amendable. Rights can be modified. But the underlying inherent meaning of these rights, that should not be amendable. This is so vague that it makes the Supreme Court the boss. Because Supreme Court can simply decide that no, this is not the essence. No, this is the essence. Anyway. Now, how many of you How many of you feel that this basic structure doctrine or this concept was a good one? It was required. Let's take a poll. A for yes, B for no. Don't choose C, please. A for yes, B for no. Don't choose C. It was actually pretty much needed in any democracy. Why? Firstly, a very logical thing is that rule of law exists, meaning limitation has to be there on the powers of the state. Rule of law, limitation on state's power. Now, one more thing. If you give parliament this kind of arbitrary power, then it can do anything now. Tomorrow the parliament can say, we are amending the constitution, and back in 1973, Indira Gandhi is now the queen of the country. That would not be correct, right? So arbitrary and random action of state, you have to prevent it. Also, see, there is an inherent identity of the constitution. The ideas of social inclusion, the idea of equality, the idea of welfare, etc. We should not modify that idea. Then the essence is lost. If you change those things only, then everything is lost, right? So that needs to be protected. And lastly, Article 368 gives the parliament the right to improve the constitution, fine tune it. Here and there, loopholes need to be plugged. It does not give you the right to redraft the entire constitution from scratch. No, that is not the right that you have. So it's very, very important to ensure that the Article 368 is used to upgrade the constitution, not rewrite the constitution. That should not be there. So this is the advantage. But there are some challenges also, some issues. First issue is that please tell me which article mentions basic structure. Is there any article which mentions basic structure? And there is no article. Now, Supreme Court also has as a part of being an organ of the state, Supreme Court's role is to interpret the constitution. I mean, you can also claim that Supreme Court, you are also rewriting the constitution, amounts to rewriting. That may not be a very good thing. And also, it depends on the subjectivity of the judge, is it not? Look at the Keshwan Bharti case only. Before the Keshwan Bharti case, 11 judges in Golaknath judgment, they gave a different judgment. Before that, the same court was giving a different judgment. Judges change, judgments change. So a lot depends on what the judge feels, subjectivity of the judge. The personal opinion of the judge. And there is no set definition. The worst thing is that there is no definition of what is basic structure. And this creates arbitrariness, right? Tomorrow, courts can add anything as a part of basic structure. We don't know. There is no such clear-cut defined criteria. The government was trying to make an NJAC for independence in appointments, and the court says, no, 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 no. Basic structure violated, cancelled it. But we don't know when you will cancel any amendment made by the parliament. And after all, when the parliament amends, it is through a proper procedure of a special majority in both the houses. So it is very, very important that in a democracy, the people's representatives have the ultimate power. Is it not an illegitimate interference on the majority rule that we have chosen somebody and then there is somebody at the top of them who's making all ultimate decisions on whether the parliament's modifications, laws will survive or not? And people said, see, if you keep on canceling things, then how will modifications happen? How will we improve? How will we upgrade our constitution? So it is just like transferring the ultimate power from the parliament to the judiciary. That's also a problem. But to cut a long story short, see, we have to understand that the applicability, content, and scope of the basic structure needs to be defined. So one thing is, definition is required. We cannot, I'm not saying exact, but at least broader contours have to be mentioned. But also let's just understand and also appreciate this, that courts have largely not misused this provision. They have not. I mean, if you look at it, there is no proof of misuse. Please tell me, when have you seen the last time the Supreme Court cancelled any amendment? 2014, 2015 rather. That's it. In the last 30 years, it has been used only once, and sometimes in 1970s. So it has largely not been misused. I mean, if we found that the Supreme Court is cancelling every change every 2 years, every 3 years, then possibly. But it has never been used, only handful of times. So courts have also ensured that they don't overuse, they don't misuse it. And also, there is international recognition. You'll be surprised to know that in countries like Bangladesh, in 1989, in one Anwar Hussain Chaudhary case, the Bangladesh Supreme Court also referred to the Keshwanand Bharati judgment in India. Or a few years back in Uganda, in one local court in Uganda in 2017, the judge referred to the Keshwanand Bharati case, stating that, see, the elected government and the parliament's power cannot be arbitrary. It has to be limited. So there's also this international acceptance. Now, one more argument which is against this basic structure is, look at the majority. It's the 7:6 majority. What kind of judgment is this? If you say that, sir, 7 judges are saying it is important, but 6 are saying it is not required. So it does not inspire confidence. It is like on the last ball, 3 runs were required, and a Yorker came. And the batsman by chance got a lemon cut and a boundary and won the match. Right? So the point is that such majorities never inspire confidence. That what if one judge had changed the side? We would not have this concept only. That's also there. Right? So this is the whole point with respect to this judgment. But otherwise, overall, this judgment was much needed and very appropriate. Anyway, solve this question asked in the year 2020. The is the answer. Bogus completely. And the Constitution provides for judicial review. No, it is not mentioned in the Constitution. This is also wrong. Both are wrong. Right? So, D is the right answer. Neither one nor. If you want to, feel free to read the chapter. There's also a question asked in the main examination, the same question. Parliament's power to amend the constitution is a limited power and it cannot be enlarged into an absolute power. In the light of this statement, explain whether the parliament under Article 368 can destroy the basic structure or not. So, in fact, you'll be surprised to know that parliament has tried all this nonsense. When this basic structure judgment came, Parliament did try to destroy it. Already tried. Through the 39th Amendment Act 1975 and through the 42nd Amendment Act 1976. In fact, they added two articles or two clauses. Clause 4 and clause 5 were added. But Supreme Court cancelled it. So Parliament did make a change. So Article 368 clause 4 and 5 say that amendments can't be questioned and there is no limit on the Parliament's power to amend the constitution. Supreme Court said to hell with all that nonsense. We can question it. So Parliament tried, but Supreme Court put its foot down and said that no, we will not let you do this nonsense. Right? So this is with respect to the changes made. So you can mention the pros, the cons, the issues, concerns, way forward, some suggestion, etc., and address this concern. A very simple, straightforward question. Yes, Mayank Advani. Yes, of course we can. So as somebody was saying, Prem Kumar, your question on because the Supreme Court seemingly is trying to destroy the checks and balances. The idea here to support basic structure is that it is also placing a limitation on the parliament's power. And if the Supreme Court becomes dictatorial, the judges can at any point of time be removed if there's a consensus in the house, right? So it is very important because judges don't govern the country. So people who govern the country, the executive, your powers have to be restricted because executive is extremely powerful in the country in a parliamentary setup. And they are practically doing everything in the country. And if there is no check on the executive, that will create more trouble. Right? Okay. Now, since we are done with basic structure, Nuti Kadi asks that, sir, Parliament wants to amend Article 368. What is the procedure? Is that even allowed? We have already seen this before. While we were discussing about Article 368 in the types of majorities, we had seen that special majority is required plus half the state's ratification is required. So that is why the questions you ask have all been explained before, sadly. And it's one more heartbreak. That's it. Okay. That's there. Mayank Badwani ji, socialism is inherently not there, but welfare system is there. So India is a welfare state that is a part of basic structure. Okay. Now let's move on to the 6 types of rights. Now we'll discuss the fundamental rights. So we have 6 different types of rights. Right to equality. 5 articles are there. 14, 15, 16, 17, 18. Right to freedom. 5 articles are there. 19, 20, 21, 21A and 22. Then right against, not right to exploitation, right against exploitation. Okay. 23 and 24. And then right to freedom of religion. 25 to 28. Cultural and educational rights. 29 and 30. And right to constitutional remedies. Article 32. These are the 6 fundamental rights. One right to property has been repealed. We'll discuss it later on. Starting with the first right or first group of rights, right to equality. Venkatesh, which article will be amended? You tell me. To amend the basic structure, which article do you want to amend? Okay, right to equality. Article 14 to 18. This group of rights are civil rights. What are civil rights? Civil rights prevent discrimination on the grounds of race, on the grounds of gender, on the grounds of say caste, on the grounds of religion, etc. That is called civil rights. There should not be any discrimination faced by any individual on these grounds. First up is Article 14, which has 2 parts: equality before law and equal protection of laws. What is equality before law? So it is a part of rule of law. Firstly, rule of law. What is rule of law? Rule of law means the state will not have arbitrary powers. Limitation on the powers of state. That is called rule of law. There should be accountability. There should be impartial justice. There should be fairness of laws. Government should be transparent. Absence of arbitrary powers limitation on states' powers. This is called rule of law. This concept of rule of law has always existed, but it has been formally defined by Edward Coke and later on Albert Venn Dicey. These people have largely helped in defining what is rule of law. Now, it simply means that there is no special privilege for any person. No one is above the law. All manner of people are equal in the eyes of law. That is what is called rule of law. Simple. That is what is equality before law. Everybody is equal in the eyes of law. No special treatment to anybody. Clear? Nobody is above the law. I hope this point is clear. We say lex rex. Law is the king. Law is the king of all the kings. Now, since we have started understanding fundamental rights now, let me tell you one thing. Please don't have this feeling that rights are absolute in nature. In our country, rights are not absolute. Fundamental rights, they are not absolute. Restrictions can be imposed on the fundamental rights. Are we clear? So these rights that you see are not at all absolute. They are all limited. And look at this. We are talking about equality before law. Don't we have exceptions? Article 361. What is Article 361? Tell me. Immunity given to the president or the governor. This is Article 361. So if I commit a murder, why will I? You commit a murder, you are going to jail. But if the president commits a murder, no jail. Yes or no? Where is the equality of treatment? It is not. Or parliamentary privilege. Article 105. Article 194. Our MPs have unfettered freedom of speech in the parliament. They can talk any nonsense in the parliament, right? Look at the recent scuffle between two MPs in the house, right? Where one MP was constantly using a derogatory word for the prime minister, and the second MP used a derogatory word for this MP only, right? Both are using the same kind of language, right? So, and you can't punish them also, because in the house you are free to use any kind of speech. Freedom of speech is there. Also, diplomatic immunity. Now, see, if you are committing a crime, you will be punished. But if a diplomat, some foreign service officer of some other country, ambassador, comes to India and he commits a crime, we can't punish them. We will send them back to their parent country, and that country will punish them. It's there for you also. If you are, say, posted in a country like, say, Somalia, Uganda, etc., any foreign country, IFS officer in South Sudan, let's say some of you are posted there, okay? You commit a crime there, they will send you back to India. We will punish you. They won't punish you. Are we clear? You can try it in future. You'll get to know. Don't try it. Okay? Have faith in me. You'll be punished by Indian laws. So, equality before law. But when you treat people equally, a concept borrowed from UK, is that always justified? A small kid, should that kid be asked, come on, compete in a boxing match with an 80 kg plus boxer? Is that fair? Tell me. No, right? Look at the photograph. Tell me what is important. Equity or equality? What do you think makes more sense? Of course, equity makes more sense. What is equity? Equity, see, equality means each individual or each group is given the same resources, the same opportunity. The same resources, same opportunity. But equity understands, it recognizes that each person has different circumstances, and equity allocates resources, exact opportunities to reach an equal outcome of opportunities. So we have to always focus on creating equality of opportunity so that both have the same chance of having an equal outcome. Are we clear? Everybody? No doubts. So this is more important. But how have we actually incorporated this? Yes, we have. The second part of Article 14, which is borrowed from USA, their 14th Amendment of the 1860s, is a more important point to understand actually. This is way more important than the first part. First part is okay, but second part actually refers to this equal protection of laws. Equal protection of laws. What is that? See, there's a person A. This person A earns 1 lakh rupees per year, and there's a person B who earns 1 lakh rupees per month. Now, if we have to impose a tax, income tax on both these people, should we impose the same rate of income tax on both these people? Tell me. No, right? Of course not. Why? Because these people are not in a similar economic situation. This person is finding it extremely difficult to make ends meet, and this person is living a pretty lavish life. Where is the equality? Since these people are not in a similar circumstance, treating them under the same law is wrong. This means that we need to treat people differently. Let's say there's one more person C. He earns 1.1 lakh rupees per month. Can we put them in one same group and treat them equally? Tell me. Okay, that may be possible. This is fair. These two people have almost similar circumstance, right? So this may be justified, but putting this person with these two is not justified. Yes or no? That's how it is. Or if you have a person D who is earning 1 lakh rupees per day, now putting these two with him, that's also wrong. So we have to create groups, group 1, group 2, group 3, and impose different tax rate on different people, right? So like should be treated alike. People in a similar circumstance should be treated similarly. You cannot treat everybody in the same fashion. That would be wrong actually. That would not just be stupid, it would be violative of somebody's basic rights. I hope this point is understood. This is called equal protection of laws. Meaning what? Meaning what? We can allow for a positive discrimination because we should not subject different categories of people to the same set of laws. Yes, reservation is a perfect example of this. And progressive taxation. Progressive taxation is what? The increase in the income tax rate with the increase in income. So it is fully justified. Now, let me just extend this point further. If a crime is committed, let's say murder has been committed by a person A and a person C. Tell me who should be given a more harsh punishment, A or C? Some are writing A, some are writing C. Why A and C? Both have committed a crime of murder. Should we now give them different punishment? Of course not. Same punishment. Because your economic situation has got no relationship to the moral crime you have committed. Right? So, there is one problem here now. When you start treating people differently, there should be some kind of logic behind differential treatment. Yes or no? Do you understand what I'm telling you now? I'm slightly widening the scope here, that there is always a possibility that when you treat people differently, sometimes the treatment which is different can be based on a very unrelated topic. So if you are treating A and B differently on tax matters, it is justified. But if you are treating A and B differently on murder matters, that is not justified. But how to check? How to check when to treat people differently and on what parameter? So there are two tests that Supreme Court has devised. Test for reasonable classification. How to classify people in different groups. So there are two tests. Test number one, it is called intelligible differentia, meaning people placed under similar circumstance should be grouped together. An example was this: we are placing B and C in the same group. That is logical. So always ensure that when you are treating people differently, you are treating a set of people in the same fashion. They should be in a similar circumstance. Don't treat Ambani and a common person in a same fashion for some monetary matter. It may be their lives are hugely, vastly different. So that is the meaning of intelligible differentia. When you place people in groups and make laws for them, the people within the group should be in a similar circumstance. Clear? Now comes the second part. I'll give an example of this to help you understand better. Sufficient nexus. There used to be a law in the country under IPC section 497. This law was the law of punishment for adultery. What is adultery? Adultery means having any illicit relationship outside the wedlock, meaning outside marriage. Beyond your marriage, if you have any extramarital affair, that is called adultery. Okay? Now take this example. How did the law function? There is a person A. A is a male. A is married to B. B is a female. Let's assume B is a female. Now what happens is B develops some kind of relationship with a person C. C is a male. Now C is married to say D. D is a female. This relationship you are seeing here between B and C, this is what is called adultery. Are we clear? Now I'll ask you two questions. Please respond. Question number one. Who is at fault here? Who is at fault? Who is committing the wrong? Okay. B and C. They are at fault. Some of you are writing only B. I'm not sure why. So A, Charan, etc. writing B only. I'm not sure why only B is at fault. C is also at fault, right? No? Okay. Anyway. So both B and C are at fault. Now, who is suffering? Second question. Who is suffering here? A and D. So A and D are suffering. This means that both A and D should be allowed to complain, and if there is any punishment, then it should be given to B and C both. Are they clear so far? Everybody? Okay. This was not there in the law. The law said that only the aggrieved husband could complain. D could not complain. Wife of a husband who was found involved in adultery, that wife could not complain to the police. Point number one. And point number two, who will be punished? Only the male involved in adultery will be punished. B will not be punished. Only C will be punished. Are you clear? 2 years of jail for C. This law was based on a very old concept, a Western idea, a religious idea, that women or wives are meant to serve their husband. The master-slave kind of relationship. And that is why the wife has no right to complain against the husband. And men are moral corruptors. Women are innocent people. So it is this male who has corrupted her. And hence, this male should be punished. Now tell me something. We have created two groups, men and women. Yes or no? Two groups created, right? First test is met. Men and women are different people. They can be kept differently. Okay. But we are treating men and women differently. Based on what? Based on morality. Right? Based on morality. That if only a man is actually a moral corrupter, women can never be morally wrong. So, when you treat men and women differently based on morality, tell me, is there any link between gender and morality? Tell me. Is there any documented evidence, or in your life also, is there any? Soyab says yes. Please explain how, Soyab. And Pooja also. Tell me, what's the link between gender and morality? However simple the question, some of you would think what, I'm not sure. There is no link. Anybody can be morally right or morally wrong. So when you treat people differently, no, PUJ Pooja, not PWJ Pooja. If you treat people differently, there should be a sufficient nexus. Link means nexus. Between the objective of the law and the classification exercise. Objective of the law is what? To punish for a crime of morality. This is the objective. And the classification is based on gender. There is no link. That is why this law violates Article 14. You are treating men and women differently on a wrong ground. If you treat men and women differently, say on some physical feature, let's say you are giving women 5 days of additional leave every month during their menstruation, it is justified because they may face difficult times during those 5 days, right? Excruciating pain. So on physical features, differential treatment is justified. We do treat women differently than men based on biological factors, don't we? Right? We have the Maternity Benefits Act. which allows 26 weeks of paid leave for a working woman when she is pregnant and she delivers a baby, because a man is not capable of delivering a baby, at least as per science. I cannot delve into the US concept of gender fluidity right now, but on a very basic idea, right? Let's not get into a debate on what is happening in USA. Okay, USA is a too advanced society, because when your stomach is full, then these ideas come in your brain. Anyway, I hope you've understood this. So when you make laws, there should be a logic between differential treatment. For example, we have the concept of voting age. Are we not treating people differently? Tell me, yes or no? Two groups, less than 18 and 18 or above. And we are saying that once you have turned 18, you are an adult, you are seen as more mature, hence you get the right to vote. Simple. I'll just extend to one last example. To contest elections for panchayats, you cannot have more than 2 children. Use the logic of Article 14 and tell me whether this law violates Article 14 or not. I'll tell you how it violates. We have made two groups. One group less than 2. One group is less than 2 children and second group is more than 2 children. Intelligible differential. Done. We have created two groups. Okay. Now, what is the purpose of this grouping? The purpose is to allow some people to contest for panchayat elections. Panchayat elections means people's participation in governance. Two-child policy means population control. Please tell me, what is the link between people's participation in governance and two-child policy? If somebody has 3 children, does his or her efficiency to run a panchayat come down? Tell me. We don't know. Actually, there's no study being done like this. That, oh, you have 3 children, you can't govern now. How can you be sarpanch? You have no skill only. No. Similarly, having a functional toilet. Please tell me, if you don't have a toilet in your house, does it take away your power to administer a panchayat? Again, the same point. These laws simply violate Article 14. Also, Supreme Court has accepted these things. That is a personal problem. But these laws blatantly violate Article 14. Still they exist in the country. Why? Because Supreme Court feels that such progressive steps can act as what? Such progressive steps can act as an example for higher levels of politics. What example can it serve? We don't know. But anyway. So this is Article 14. The first part talks about equality, but second part talks about the differential treatment. Clear? Don't worry, adultery is no longer a criminal offense. Does not mean you should do it. It has been struck down by Supreme Court in 2018, Joseph Shine case, as unconstitutional. And look at this, such a stupid law. Why should the state be involved in the first place? Right? Forget the violation of Article 14. Think of it. Why should the state be bothered if somebody is having an extramarital affair? It's their personal problem. A or D should go to a family court, get a divorce. Or A can have an affair with D. That's your personal problem. No, I'm not giving any suggestion. I'm simply saying This is a personal problem. Don't involve police and courts here. Right? Okay. Anyway, so this is with respect to the Article 14. Clear? Solve this question. Came in 2018. Read the statement carefully. Mark the answer. Rule of law, equality before law. Rule of law, liberty and civil rights. 1, 2, and 4. Civil rights, limitation on state's power, equality before law, rule of law. All explained right now only. So C is the right answer. Look at this question asked in don't circumstances of what happened in the crime. What is mentioned is important. A legislation, it always was limited power, and then the courts can cancel that particular law because it violates Article 14. Are we clear? That was Article 14. Moving on to the next article, Article 15. Have we seen Article 15, the movie? Has anybody here seen Article 15, the movie? Don't worry. If you have not, you have lost nothing in life. Don't panic. It's okay. Basically, one more thing now. There are certain fundamental rights which are meant only for Indian citizens. Today is first day of class. Oh, Kriti, Article 15 is a movie. We don't play that in the class. We will never play in the class. Don't worry. Okay. So there are some fundamental rights which are available only to Indian citizens. There are 5 such rights only for Indian citizens: 15, 16, 19, 29, and 30. Please repeat with me. Speak it out loud wherever you are. Don't disturb other people. Don't shout. Speak it very softly with me. 5 fundamental rights available only to Indian citizens are 15, 16, 19, 29, and 30. Clear? Okay. So Article 15 is available only to Indian citizens. And what is that? The state. Same Article 12 definition. The state shall not discriminate against any citizen on grounds only on these grounds, only of religion, race, caste, sex, place of birth. We call it RRCSP. RRCSP. No discrimination on grounds of RRCSP. Are we clear? Everybody. The state will not discriminate, but then there are government colleges for girls. Yes or no? So, what do we do? Dharna tomorrow in front of college? Tell me. Let's go and protest. No, guys, please don't. Some of you are leaving the class and going for protest only. Wait. Before leaving, read this article also. Same Article 15 as clause 3. Nothing in this article shall prevent the state from making any special provision for women and children. Are we clear? So, yes, the state will not discriminate, but the state is allowed to make special provisions for women and children. So, please don't leave, because if you go and protest, they'll firstly slap you. That half-baked information, WhatsApp forward knowledge, get lost, right? So this, okay. So interestingly, Article 15 says, clause 1, that state will not discriminate. Can other people discriminate? No, they also cannot. Because clause 2 says that no citizen will face any kind of discrimination on the grounds of religion, race, caste, sex, place of birth. You will not face any disability. No extra liability will be imposed on you. No restriction, no condition will be imposed on you just because you are of a religion or of a race or a caste, sex, or place of birth. For access to shops, public restaurants, hotels, places of public entertainment, use of wells, tanks, bathing ghats, etc. Right? Clear? So, you are prohibited from discriminating against any citizen on the grounds of RRCSP. Now, please answer questions very quickly. Does the state not discriminate on Article 21? Oh, no. Does the state not discriminate on right to vote? Yes or no? It does, right? Some people are allowed to vote, others are not. Does that violate Article 15? No. Why? Because the discrimination is on the basis of age. Age is not mentioned here. UPSC discriminates on the basis of educational qualification. Only graduates can apply. Right? Meaning what? Again, it is also allowed because this is not mentioned here. Only on these grounds you can't discriminate. Meaning, on other grounds, discrimination is possible. So, if you go, you see a flat on rent, an ad, a public ad, a flat on rent, and you go there and the flat owner asks you, do you eat non-vegetarian food? And you say yes, every day, 3 times a day, and I drink also alcohol. The flat owner says, leave immediately from here. Has he violated Article 15? Tell me. Why not? If he has, why? And if he has not, why not? He has not violated Article 15 because food is not mentioned. You can face discrimination based on food habits. Are we clear? Okay, very good. Next, one more question. If now the flat owner asks you, what is your religion? And you say, I am a Hindu, I am a Muslim, I am a Christian. And he says, get lost. I give house only to Sikh people, only to Jains. Is this violation of Article 15? A place he has allowed everybody entry, but except a person of a religion. Yes, of course, it violates Article 15. Religion is a ground on which you cannot discriminate. Now, one more question. This is a true story. There were these kids begging on the signal. The kids that you see beg on the signal. These kids collected some money and wanted to go to some food joint, some fast food joint, KFC or Burger King or whatever or some MacD or Pizza Hut. I'm not sure. No, I don't know. I don't want to name it. So they went to that food joint. Now, the manager there did not allow them entry. The manager did not allow them entry, access to shops, etc., or any place dedicated to use of public. Does this violate Article 15? Yes or no? Don't write yes or no. Write yes or no with reasons, ground. Some of you are writing yes. Based on what ground? Based on caste. How do you know the caste of the person? Place of birth means the area of birth, right? So how do you know where they are born? You don't know. Race, all are of same race only. Caste is class, Devyani. That may not always be the case. Please, guys, don't become emotional. It is not violation on the grounds of RRCSP. That violation is not discrimination under Article 15. Are we clear on this? Clause 2 of this article prevents discrimination on the same grounds. RRCSP. Please understand the point here I'm trying to make. The discrimination can be on the ground of only these things. That is what is called violating Article 15. If you discriminate on somebody's dressing sense, hygiene, food habit, that is not called discrimination under Article 15. Are we clear, everyone? If tomorrow you go to a, say, Mercedes showroom and they throw you out, get lost, then you can't go to court. Court, mein Article 15 is violated, right? Okay. Like in Starbucks, we can't go. Who told this to Ananya that in Starbucks we can't go with chappals? No, no, no. That is wrong information, right? But yes, in certain clubs, they may not allow you entry inside with slippers. In clubs, no, no, wrong information. No, private property, but the point is if you have opened the property to public use, you are giving it out on rent to any and every person, then it becomes a public, which a property where you are allowing people entry, but restricting the entry based on religion. Are you able to understand? Then hotel is also private property. Okay. So I hope VK Kush, your doubt is resolved. Okay. This is Article 15 done. Clause 1, 2 and 3. Now, Prem Kumar, domicile means where you live. Place of birth is where you are born. Yes, Article 15 Clause 2 is again enforceable against the private property. Ritika, so what's the problem? Be explained. Pavitra, you are an earlier weekend batch student. You want to explain again? The use of wells, tanks. Now, don't say what is a tank. It is not an army tank. Please understand that these articles were made in 1950. Okay, 1946 to 49. They did not know places like motels, spas, etc. Right? Food joint. So don't say, sir, food joint is not mentioned. Sir, spa is not mentioned. Sir, salon is not mentioned. They did not know all these places. The assumption is that everything is included. Don't ask such kind of questions. Okay. The use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. Either it is maintained by the state or it is meant for public use. These are two different things. Are we clear on this, everybody? Including Mayank Vadwani and Pavitra? Okay. It is now a public place. Okay. If you are allowing entry of everybody there and you are restricting entry based on certain religion, then that is wrong. Now, please let me help you understand one more point here. When you go to court to claim Article 15, it is your duty and the onus is on you to prove that you are facing discrimination on grounds of RRCSP. For example, you can go and say, why is there this PG for girls only? I want a room here. Discrimination. Article 15 getting violated. RRCSP. I want to live here. Some enthusiastic aspirants here can do this drama. But the PG owner can simply say, no, it is based on morality. Simple. And when you go to court, the court may also ask you to get lost immediately and don't waste time of the court. Are we clear? So when you go to court, you have to prove that the discrimination is based on RRCSP only. It is not the responsibility of the person discriminating or the court. Are we clear? So every discrimination can have multiple sides to it. Okay. Now this was see, I will come to all the provisions slowly and steadily, including don't involve temples right now. We'll come to religion under Article 25 and 26. Let us firstly focus on this. Now, this was Article 15, Clause 1, 2, and 3. What happened later on, or rather, what happened because of something which existed in this country was some Supreme Court judgments and some changes made by the Parliament. So back in the 1930s and 40s, in the Madras province, there used to be a communal government order. That order was called a communal government order in Madras province. According to this order, in the engineering and medical colleges in Madras province, seats were reserved. Seats were reserved for kids based on their caste and religion. For example, 6 seats were reserved for non-Brahmins, 2 were reserved for Brahmins and backward communities, 2 for scheduled castes, 2 for Anglo-Indians, 1 for Muslims, 1 for Christians. Now, if you reserve these seats for certain people based on their religion and caste, it directly violates Article 29, Clause 2. Also Article 15. Look at this article. 29, Clause 2. What does it say? Let's read very slowly. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on the grounds of religion, race, caste, or language. So, in any government school or college, you cannot be denied admission or you will not face a discrimination just because you belong to a certain religion or a race or a caste or a language. So the Madras government order was creating a discrimination on the grounds of religion as well as caste. One Champakam Turai Ranjan, this lady, she could not get admission in the medical college because she belonged to the Brahmin community and the seats for which were allocated for Brahmins were already filled. So she went to the Supreme Court. Supreme Court cancelled the Madras government order and said that quota in educational institutions no longer exists. Why? Because it violates Article 29, Clause 2. So, we said that no reservation in educational institutions. What did the Parliament do? Parliament passed the First Amendment Act 1951. And with this Amendment Act, Parliament said nothing in Article 15 or Article 29, Clause 2 can prevent the state from making special provisions, meaning reservation, for three communities: scheduled castes, scheduled tribes, and socially and educationally backward classes, OBC, other backward classes. So the modification was made that three communities, the state will provide for reservation in educational institutions in all government schools and colleges for these three communities. Are we clear? This marks the beginning of reservation in educational institutions. Are we all okay with that? Everybody so far? Great. When this particular change was made, it was found that slowly and steadily, lot of these states started imposing reservation even in private schools and colleges. This was challenged by the people. What was the problem? The problem was that there is an article 19(1)(g). Let's read this article also. All citizens have the right to practice their profession or carry on their occupation, trade, or business. POTB. Profession, occupation, trade, business. You have a right to carry your occupation, trade, and business. If the state says, please admit certain students because I am telling you, I'll say, no, it's my school or college. Why are you telling me what to do with my school or college? Imagine you are running a shop and the government says, no, no, not your son or daughter. Hire somebody else to own the shop. Why? It's my personal property. I have a right to manage my school or college in the way I want to. So Supreme Court said quota in unaided. What is unaided? Which do not receive government funds. Unaided educational institutions, there will not be any quota because it violates Article 14, it violates Article 19(1)(g). Why Article 14? You are treating public schools and or government schools and private schools in the same fashion. That is wrong. Cancelled. Again, the Parliament said no, 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 no. Again, they passed a 93rd Amendment Act and said, sorry, we can make special provisions for SEBCs, that is OBCs, for scheduled castes, for scheduled tribes in any school or college, whether it is aided or it is unaided, does not matter. Government school, private school, government college, private college, we can make reservation. Whether we do it or not, that is separate. We can do it. The only exception is a minority educational institution. MEI in a minority educational institution, we will not, but otherwise we can. Simple. This is what is the reservation policy of the country vis-a-vis the education system is concerned. So it was not there originally, but was added later on through two amendments, one in 1951, the other in 2005. Are we clear? See, minority educational institution is a school or college which is run by minority community. Okay? Ritesh, but in my school there was no reservation. Ritesh, what did I tell you just now? The state can make, right? Can make. If they want to, they will. If not, they will not. They did not think your school was good enough to make a reservation. Not that reason. They must not have done it. Simple. So it is not a mandatory provision. It is an optional provision. Are we clear on this? Everybody? Okay. Great then. Now we are done with the Article 15. Just one small point. So basically, we provide for three categories of reservations. We provided for scheduled castes 15%. We provided for scheduled tribes 7.5%, and socially and educationally backward classes 27%. In 2019, one more clause was added to Article 15. Clause 6 was added. And now one more category was introduced. Those people who so far belong to no category, the unreserved category. From that group, the economically weaker section, EWS, these people would be given reservation up to 10%. So now we have exactly 10% reservation for economically weaker sections. Are we clear, everyone? And the central government will notify who would be called an economically weaker section based on family income, like 8 lakh rupees is the current limit, and other such factors like land holding, etc. And in the Janhit Abhiyan case 2022, Supreme Court upheld the reservation of EWS to be constitutionally valid. So now we have EWS category also as a category which is there, where 10% seats are reserved for certain communities who are put under the economically weaker section. This brings us to an end of our Article 15. Did we understand? Okay. So far we were looking into Article 15, which was in the field of education, which is of no concern to you. You have all crossed the education field. Now comes the article which directly impacts you, and most of you are more affected by this provision. So, Article 16, equality of opportunity in public employment. So, the article says that there shall be equality of opportunity for all citizens in matters of public employment. In government jobs, no discrimination. No discrimination in matters of employment on the grounds of religion, race, caste, sex, place of birth. RRCSP. Also descent and residence. Descent. What is the meaning of descent? Ancestry. Descent. So on the basis of descent or your hereditary succession, ancestry, you will not face any discrimination, neither on the basis of residence will you face any discrimination. That is why, if you observe, residence is not a criteria in schools. So in lot of these schools and colleges like say IIT, NIT, some seats are reserved for people from Rajasthan, some for Tamil Nadu, some for UP, some for Delhi, some for Gujarat. Yes or no? Have you observed this in certain schools and colleges? So why is that the case? That is the case because in a college, residence can be a ground of discrimination. But in government jobs, these will not be a ground of discrimination. Just because you are born in some place, we will not discriminate against you on government employment. However, however, the parliament is allowed to make laws making residence as a criteria to get a government job. So residence can be used as a ground of discrimination, but parliament can make a law. States have no power. Are we clear? So there are various such provisions which allow certain states to provide for reservation for their local people in government jobs. Because parliament has made laws, not the states. And let me just clarify a very, very important point. So this is a large misconception. Supreme Court, what it has said. Supreme Court on residence-based reservation. So what Supreme Court has said in the Pradeep Jain case, 1984, is that residence-based reservation is ultra vires the constitution. Such reservations are ultra. What is ultra vires? Tell me. We have seen this word earlier. Ultra vires, outside the scope of, beyond the scope of the constitution. Are we clear? Residence based reservation is not allowed. Not allowed. So if any state tries to do it, the courts cancel the reservation. Maharashtra 80%, Gujarat 85%, MP 70%, Andhra Pradesh 75%, Karnataka 75%. It's all cancelled. Recently, Haryana tried to do it, 75%. That matter is pending in the High Court. Now the discussions resumed last month. But again, the judge who was hearing the matter, after he heard all the matter, he was transferred to Rajasthan High Court as a Chief Justice. Again, the matter is pending. But that matter is pending in the court, right? And the Supreme Court has said that if the private organizations are not following the reservation, you can't punish them. So that reservation is not applicable actually. So whether in the Suranda Reddy case, Kailash Chandra Verma case, any case you see, Supreme Court always cancels reservation based on residence for local people. It never supports it. But one small point, if I am the state government and I want to provide jobs to my own people, what can I do? You're not allowing me to give reservation based on residence. So I can't make a reservation that people living in West Bengal, people living in Tamil Nadu can only apply. What to do? States use language as a criteria. To get around the Supreme Court judgment. Are we clear? Now, if you use language as a criteria, then what happens? Very simple. Tell me, why would a Tamilian learn Bengali? So, of course, if you say that you need to also qualify a Bengali paper, of course, a Tamilian is out. Why would somebody from Maharashtra learn Kannada? If you say you have to have working knowledge of Kannada, Maharashtrian is out. If you say you have to have skills in Marathi, language fluency of Marathi, then somebody from Nagaland is out. So very simple. So states use a criteria of language to get around this idea of local reservation. But anyway, because language can be used, language is not mentioned here. It can be used. Okay. Now comes the article which was there in the constitution since the very beginning. This is not an addition by the parliament. It was there originally in the constitution, right? Article 16 clause 4, and this article provides for reservation in government jobs. Reservation in schools and colleges was not a part of the original constitution, but this was a part of original constitution. State can make reservation in favor of backward classes if they are not adequately represented in government jobs. If the state feels that some group, a community, does not have many people in government jobs, then for that community, reservations can be made by the state. Are we clear, everyone? Any doubt? This is the policy of reservation which was embedded in the constitution at the behest of Dr. Ambedkar. Okay, and originally, for how long this reservation, there is no limit of this reservation. The limit is till the communities are not adequately represented, we'll have to provide for reservation. Simple. That's it. That's the limit. Okay. How to define these communities? We'll look into it. State means center or state, both. So a very valid question would be how to define this. Mayank Wadhwani, simple majority. So we have three communities which are given reservation. Now for EWS, three communities. One is the scheduled caste. The other is scheduled tribe. And third is SEBC or OBCs. It will require at least 15-20 minutes. Are we up for extending the class over 15-20 minutes? Okay. Let me explain the criteria for scheduled castes. Point number one, scheduled caste people belong to certain religion only. Are we clear? They can belong to only Hindus, Sikh, or Buddhists. A Muslim cannot be a scheduled caste person. A Christian cannot be a scheduled caste person. You can call yourself a Dalit Christian. It makes no sense. The reservation benefits will only be given to HSB, Hindus, Sikh, and Buddhists, not even to Jains. Are we clear? Everyone so far. Point one. Now let's move on to further extend this idea. So, scheduled caste identification is done by the president. There is an Article 341 which talks about the scheduled castes. So, president will publish the list. This list contains the names of all the communities which are incorporated in the scheduled caste. And this list is called Constitution SC Order of 1950. You have to constantly update this list only. And who will update the list? The parliament. States have no power. Parliament can make modifications. So every scheduled caste community finds its name in this particular list. Now, what is the reason for giving reservation to scheduled castes? The reason is historical injustice. Historical injustice. Now, one more thing. How to identify these communities? So, identification of scheduled castes comes from two avenues. Point number one, untouchability. Either through proximity or through touch. And number two, denial of temple entry. But what is the source of this? So back in 1929, a census commissioner was appointed, John Henry Hutton. And in 1933, he published a report called Hutton Committee Report. In this Hutton Committee Report, the British Indian government was trying to create a caste census. So basically, they wanted to list the names of all the people who belong to various castes. Now, I think you all know the Varna system or the Varna system. So the Varna system says that we have four Varnas: Brahman, Kshatriya, Vaishya, and Shudra. But there are certain people the Hutton Committee found who were not a part of the Varna system only. He called them exterior castes, exterior, who were outside the Varna system, right? And or depressed classes. And he tried to identify what is the common trait. And then he prepared a list. The list was called a schedule. And he put all those names of all those people who were facing untouchability and were not being allowed entry into temple and put them in the list. Hence the term scheduled caste, because it is a schedule of the Hutton Committee report, which lists the names of all these communities. And what is the origin of untouchability? The origin of untouchability was the marriage system in the country. So see, normally, Sir Prem Kumar will address the concern. You have lack of knowledge there. Don't worry. I'll correct your knowledge, but tomorrow. I got your point. Mandal Commission. You don't have information there. Let me correct it tomorrow. See, in the marriages, I think you'll all agree on this. Even today it is visible. And earlier also, an upper Varna person, boy, was allowed to marry an upper Varna girl. But upper Varna boy was also allowed to marry a lower Varna girl. It was okay. Such marriages were called anulom marriages. Clear? But what was not allowed was a lower Varna boy marrying an upper Varna girl. That was called pratilom. Pratilom marriage. Against the nature only. Even today, no concerns are raised when a Brahmin boy marries a Dalit girl. But if a Dalit boy marries a Brahmin girl, all hell breaks loose. Yes or no? This is a reality even today. Pratilom marriages were not allowed. Now, what they did was how to dissuade such marriages. They started ostracizing these people, outcasting them from the society, pushing them out. that we will not interact with such people, started treating them as untouchables. The kids of these marriages were called chandals. Chandals is the origin of untouchability, right? And what used to happen was they were sent outside the villages. They would live outside the villages, and slowly and steadily, more unique forms of untouchability were introduced. Like, don't touch these people because you get polluted. Sometimes you should not allow them near you also. If they come near you within range of say 10 meters, one hand distance, you get polluted. These were unique ideas created by us to discriminate against people for over 2000 years. More than 2000 years of discrimination. There are cases where the people had to tie a broom around their waist. They had to attach a broom around their waist. And when they walked, the idea was that the broom would sweep the road, making the road pollution free. Otherwise, when you walk on the road, you are polluting the road. And what if an upper Varna person steps on the road? He gets polluted, right? Or sometimes a pot had to be tied around the neck, right? So if the spit, saliva, fell on the road, an upper Varna person put his foot on the saliva, he would get polluted, right? Or a bell had to be tied like an animal, that when the person went somewhere, the bell sound would inform others that an untouchable is coming to the area. Don't look at him or her. There is a case of a community called Puradavannans. So this is in Tirunelveli district. So Tirunelveli, Britishers used to call it Tenne Valley. Now Tirunelveli. In this district, there was a group of people who were not allowed to come out of their house during, forget house, they lived in den-like places outside the village. They were not allowed to come outside their house during daytime. Why? Because if an upper caste person saw them, he would get polluted. So these communities for generations and generations were supposed to live in their dens only, their caves only. They could only come out at night. So Hindu newspaper in 1932 wrote this article mentioning about these communities and said that these communities are not allowed to come out during daytime because their mere sight is enough to cause pollution. And these communities have to leave their dens at the dark and scuttle back home at dawn like badgers and rodents and rats and mice. This is what Ambedkar quoted in his speeches and said that no civilization can be held guilty of a greater cruelty, subjecting people, generations and generations of people, to this kind of atrocity. And then there is a very infamous Mulakkaram, the breast tax. So in the princely state of Travancore, there used to be a breast tax. Women of the scheduled caste communities were not allowed to cover their breasts until and unless they paid a tax. Direct violation of somebody's privacy and dignity, right? For generations. And then there's a legendary story of Nanjali, who supposedly did not pay the tax. The king's men came and she chopped her breasts and then she died, right? Now, these could be legendary stories and all, but everybody agrees that there was an oppressive tax regime which was there on the scheduled caste communities. And interestingly, when you looked at these communities, you were polluted. But if you had to remove a dead carcass, dead animal's body, then you call them only. So back in the old days, we did not have toilets, the sewage system. So there used to be a pit system. You would have an elevated platform, and in the ground, the hole is dug, and people would go and relieve themselves, nature's call, right? And all the excreta, the human feces, the latrine would get dumped in that pit. The pit had to be manually cleaned. Somebody had to enter the pit take out the latrine from the pit and throw it outside. Who will do it? These communities. For generations and generations, the people subjected a group of people to this kind of atrocity. Where is the equality? It still happens today. 99% of manual scavengers are scheduled caste people. Remaining 1% are scheduled tribe people. 70% of Group D jobs, Safai Karmcharis, are scheduled caste people. Now the upper caste people, supposedly upper caste people, are entering these jobs because of salary, because the government does not pay less than 18,000 to any person. That's the minimum wage, right? And even today, if you observe some data, you will find that Hindu upper caste families, they hold 41% wealth in the country. They are 4 times richer than the SC families. The total estimated wealth of SC/STs is less than 12%. The NCRB 2021 data, government records, NCRB data says that there's a crime committed against a SC person every 10 minutes. Every day, 10 Dalit women are raped in this country. And that is just recorded information. Reported data, not the actual data. In fact, back in 2014, a survey was conducted, the Indian Human Development Survey by NCAER, the National Council of Applied Economic Research. This survey asked people 2 questions. Will you or anyone in your family prevent an SC person from entering the kitchen? Will you or anybody in your family prevent an SC person from using your utensils? You'll be surprised that 52% Brahmins said, yes, we can't allow all this. 30% Hindus, 35% Jains said, yes, that we can't allow this. 30% rural people, 20% urban people said, we can't allow this. Where is untouchability? It is still there. The forms have changed. The practice continues. There was a social attitudes research survey conducted 4 years back, where it was asked, should there be a law to prevent high caste and low caste marriages, intercaste marriages, to prevent them? 27% people in Mumbai, the financial capital, 27% people said, yes, there should be a marriage to prevent intercaste marriages. In Delhi, 40% adults said, yes, there should be a law. In Rajasthan, 60% rural people said, yes, there should be a law to prevent intercaste marriages. What kind of equality are we talking about? When a Dalit person simply wants to go to his marriage sitting on a horse, a female horse, a ghodi, a mare, and the upper caste women sit on a dharna, that sitting on a horse going to your marriage is a right reserved only for upper castes. Where is the equality? There is no equality, right? This sham of equality looks nice in your cities only, but largely the practices have continued, right? And when we talk about merit, efficiency, the starting line must be the same. You cannot subject somebody to constant derogatory remarks. You cannot subject somebody to a lifetime of abuse and then tell him, come on, compete with me. No, he cannot compete with you. Your merit is assisted merit. Generations of assisted merit, right? So the benchmark of efficiency, if it is grounded in excluding certain people, we'll only get a result. And what is the result? The result will be a pattern of governance which will be skewed against the marginalized. That is why we have to take into account the social realities and undo centuries of wrongs, discriminations meted out against the scheduled caste people. That is why even your economic situation, if it changes for an SC person, the stigma attached does not change. That's the sad reality. And then we become very angry and upset that for the past 70 years, reservations are there for SCs and STs. How is this happening? Where is the equality? Sir, for 2000 years they have suffered. And they take handful of seats. And 10 lakh people in the country claim that if there was no reservation, I would be an IS officer. No, sir, no, ma'am, you would still not be an IS officer because you don't understand the realities of life. That's a sad affair, right? There is no data to correlate merit, not at all. In fact, I will tell you data. The Stanford University conducted a survey along with AICTE and World Bank across first and third year students in all the IITs and NITs. It found that of the 45,453 students, the learning assessment, the outcomes of it for SCs and STs was far better than the other communities. So what should we say that SCs, STs are better? No, they're equal, same people. The idea is to ensure equality of opportunity. Simple. That is why, please understand that a meritorious candidate, we talk about merit a lot. Meritorious candidate is not merely one who is talented or who is successful. No, but also one whose appointment fulfills the objective, the constitutional goal of uplifting the members of the SC/ST communities. And I'll just close with giving an example of how forms keep on changing, but the mentality never changes. And you can't hide that for long. When people say with pride, I have been a part of an inter-caste marriage, it is just a marriage because you are still hung on that caste system that you think you've done something great to marry somebody outside your caste. It's not an achievement. It's a very natural thing. In 1990s, we'll see tomorrow, the Mandal Commission. In 1990s, when the OBC reservation was implemented, pass out kids went to Delhi to protest. And how did they protest? They took brooms, jhadu, brooms, and started sweeping the streets as a mark of protest. Why? Because if you give those jobs, our jobs, to these people, then we will have to do their jobs. Because cleaning the latrines and gutters is a job for a community, and all the best jobs are meant for that community only, right? It's reserved for our community only, the birthright. God has told us. In 2005, when the IIT IM reservation came into picture, parents took their kids, small kids, to Connaught Place, Delhi, made them sit with a shoe brush, and shoe polish, and told them, polish, took photographs, protest. Why? Because if our kids, or if your kids, or those kids go to IITs and IMs, then our kids will have to do their kids' jobs, those menial jobs. Because our kids, as per God's wishes, are meant to do greater things in life. This is the trauma, this is the injustice that a large section of this country has suffered for over 2000 years. So if somebody says that we have given reservation of handful of seats for 70 years, let's remove it. You are in a fool's paradise to be even thinking of this. Anyway, let's end our discussion here only. Tomorrow we'll continue from same point. We'll discuss the scheduled tribes, how they identified, the OBCs, and also the very famous Mandal case, and then the Supreme Court judgment, and then other provisions of fundamental rights. Okay, that's all for today, guys. Jai Hind. The class tomorrow is at 10, so 10 to 8 we'll have a full long